Good morning. This is class for February 2nd for business law spring semester. So I'm going to do a screen share and we'll run through the slides for today. You can use this as a resource. And then of course, as you're going through this and you have questions, you can always reach out. This is just for people who aren't physically in class today. So chapter 1 in our book is Intro to Law. It is just the very first, I don't even know if it has, page 2 in the book is where chapter 1 starts. So the very first thing that the book discusses is this small scene about a biker bar. So essentially a group of bikers walks in, they walk past the bouncers. Each one of them has all of the insignia about being in a gang on their vests. It is against the rules for these people to be in the bar or to not necessarily be in the bar, but to be known gang members in the bar. Once they walk past the bouncers, they are served, they sit down, they have some drinks. And then a bit later, they attack a man in the bathroom, they beat him, took his money. The innocent man that they attacked has lifelong injuries as a result of the crime. So the question is, what kind of legal issues have arisen? Clearly a crime has been committed because someone has been attacked. But some of the things that we're going to touch on in this class is the liability of that bar. So what are the liabilities of the businesses in this instance? And we'll get into more details about this specific case further in the chapter. I think it's essential to know that the law touches every single thing that you do. And likely even this morning, you have touched the law in a number of ways. If you put your seatbelt on the way to class this morning, that is a law that's been passed nationwide at this point. If you're a voter, if you're investing in any companies, if you own a business especially, which is most of what this course is about, as a student, if you took out student loans, those are regulated by certain industries. What we can teach, how we teach, maybe not necessarily at the college level, but certainly K through 12. Like I said, if you drove here, if you have signed a lease agreement, I think you've even signed lease agreements as students. So there, if you live in the dorms, do you own a dog? Is that dog licensed with the city? Every single thing that you do somehow touches the law in some way. So why do we have laws anyway? I mean, what's the historical purpose of them? I think that you guys have probably discussed a number of these things in other courses, so I'm not going to go into the history of law by any means. But essentially, and I say this a lot to my friends, we're trying to have a society here. You need to use your blinker and you have to use a crosswalk because we're all working together to live in the same space. And so we have to function with a group of rules, and those are called laws. So we can't just steal things we want to steal. We can't kill people if they make us angry. We have to have an enormous set of rules because there's an enormous amount of us. So I think the secondary question, and this is more certainly, I think maybe since the 80s, why are we so entertained by the law? A section in your book calls it laws of fascination, but think about all of the things that we listen to that are legal related. So like murder mysteries, like podcasts. I know almost every woman I know listens to a crazy amount of murder podcasts. Court TV, Judge Judy, and every single crazy judge show like Judge Judy that's absolutely terrible. Celebrity trials on TV. Your book mentions the O.J. Simpson trial, but I'm sure there have been, better trials since then. I'd like to talk about it in class because I haven't really paid attention to them that much anymore. I barely watch TV. But when I do, I watch First 48. Like that's exclusively what I watch on television, mostly because it's a show that wouldn't exist if people just said, I'd like to speak to an attorney. And then the entire show, the entire premise would be non-existent. But we used to have Cops and Life PD. And then over the summer, they stopped airing both of those shows. But we use laws of fascination in an enormous way in the United States. So for the origins of US law, there is no, and I get this question a lot for, the stuff that I do for a living. I run a compliance company, and I'll often have a client say to me, can you look up to see whether we can do X, Y, or Z? And there is no book. There is no place that you go that gives you all of the answers that you're looking for. There's no book that says don't kill people. You could say biblically there is, but there's no book of just laws in the United States. That's not how things work here. Essentially, our law is rooted in England. Most of the settlers from across Europe came through that way. And so we have all of our laws rooted in the same way that England had founded their own laws. So we get our criminal law system directly from England, our landlord-tenant law. I mean, even the word landlord comes directly from England. All of our contracts principles and the way we buy and sell trade property in the United States is based solely in England. And then one of the major parts of the United States law is a thing called common law. And clear back in 1250, the concept of something called precedent was first theorized. So precedent's going to be used a lot. You've probably heard it used a lot, but it's basically a doctrine that requires a judge to look back on cases that have been decided before, and then use those results from previous cases to decide current cases. So this allows us to have some kind of predictability. So when we say, what's the law? We can say, oh, well, we know in these cases in the past, this is what judges have decided. So that's now the law. And that's called our American common law. And the accumulation of all of that precedent is what makes up the common law. And it changes from time to time, depending on, new facts, new kinds of cases that come about, that sort of thing. So essentially, a judge or a court has seen this issue before. They take the same rules they applied before when this happened, and then they decide using those same rules. That's called precedent. So the Constitution, we've heard a lot of chatter about that lately with all of the people trying to take over the government. But we're covering some stuff that you've probably covered in like your senior government class or maybe an 8th grade government class. But it just sort of sets the foundation for some of the stuff that we're going to talk about. But essentially, what does the Constitution do? It's basically responsible for 3 things. It establishes a national government. It sets up 3 branches. It creates a system of checks and balances so that, all the power doesn't rest in one area. And it guarantees basic rights to the American people. That's the entire point of the Constitution, just those 3 things. So to discuss the branches of government, if you don't know what they are at this point in college, it's going to be a long semester. But essentially, our founders came from a place where there was one king and he gave all of his stuff to his friends. So breaking up that stuff was really essential for the founders of the United States. So they set up a legislative branch, which is our Congress, the executive branch, the president, and the judicial branch, which is the Supreme Court. So when we use the term checks and balances, I think a lot of people misunderstand what that actually means. And I'm the first to say it, that it drives me crazy how slow the government works. I mean, I always prefer private business as opposed to doing anything with the government because they take forever. Efficiency is not their strong suit. The issue is it was designed that way. It's designed to be slow moving, and the preference is to get nothing done rather than too much done. That's kind of the idea behind the way it was created. The point of creating lots of checks and balances between each other is so that unless everybody is in the majority of agreement and they can get that entire ship sailed around or turned around in the ocean, then things aren't going to change at all. And we see that often. But essentially, the president can veto legislation, Congress can impeach the president, the Supreme Court can void any laws passed by Congress. The president can also appoint the judges, and the Senate has to approve. So they all work in tandem to get things done. And often it seems like they never get anything done, but that is intentional. So there's a really good chart on page 8 of your text. If you want to look at kind of the sources of law, but this is sort of just a rough visual explanation of how laws are kind of look in the United States. And then also in your book goes over, exactly how this looks. But the state governments are set up the same way. Each state has a state constitution, and we have state Supreme Courts and legislators in our states, and we have state Supreme Courts. So those all work the same way, whether they're state or federal. Here's another visual of kind of the sources of law in the United States and how they're set up. And kind of not necessarily, which one's bigger, or bigger, better, that sort of thing, because they're all certainly relevant. But these are definitely, they're detailed differently. So case law is where our common law comes from, and there's an enormous amount of it. There's an enormous amount of case law because basically it's just a gigantic study in human behavior over the history of time. And so there's an enormous amount of it. And then our Constitution is obviously a very short document. Fundamental rights is something that is talked about a lot in the current landscape. So our Constitution grants people certain rights. And now most of the individual rights that are given to US citizens are located in the amendments or the Bill of Rights. That link in this presentation goes directly to that transcript. So you can actually read the actual Bill of Rights. You can see its original document. So when you hear people say, oh, I have freedom of speech, they're referring to the Bill of Rights, and that's in the First Amendment. And most of them should probably read it. So one of the second sources of law are called statutes. So Congress has the power to pass laws. Those laws are called statutes. It could cover any topic. It can, from murder to mayhem. They cover any topic on what they want to create a bill about. And the idea or the concept of what they want the new law to be is called a bill. And that bill has to win a simple majority of both the House and the Senate. And then the president can decide whether to sign it into law or to veto it. So it has to go through, laws have to go through a number of steps before they become laws, which would surprise you since we have so many of them on the books. We have an enormous amount of laws, but that's, we've been a country for a couple hundred years now. So a lot of members of Congress have passed through a lot of bills. So as we discussed before, common law is also a source of most of our law. And that's using precedent to decide legal matters in court. It's one of the major sources of law in the United States. But it should be known that this is only for lower courts. So the Supreme Court doesn't have to use precedent, which often benefits us. So we have Supreme Court decisions from, we'll probably discuss this in class, and there are probably far more examples of this, but the only one I'm thinking of right now is segregation. So the Supreme Court decided decades ago that that segregation was to be upheld. Then the same issue arises decades later, maybe 100 years later, to the Supreme Court, where they struck down segregation. So the Supreme Court can look at one issue at one time, where we're at in the United States, and then look at the same issue later and decide it differently. They don't have the requirement to use precedent in their cases. So when I ask, is there evidence of this? Segregation was the only one I could think of, but I'm sure there are lots of others. We also have court orders, and those are more on the local level for the most part. These are where I'm most familiar with them. But essentially, a court order binds a person or a business to a certain obligation. So generally in business, we call these injunctions, which means the court has said you either need to do or do not do a specific thing. So the court can say, you must sell your home in a divorce, or you must pay the landlord what you're owed them. These are they're called injunctions. There's also a protection order. If you are an abused spouse and you need protection from someone that you've just kicked out of your house, the judge will file a protection order, which is an order from the court specifically telling one of the parties to stay away from the other one. You can have an order to enter rehab. Say you're arrested on a drug conviction. The judge can say, you have to go to rehab for 90 days. He has to sign an order in order to make you do that. Businesses can be ordered to produce documents. I don't know if you've ever heard of, you've heard of companies maybe staying up all night shredding documents. I'm trying to think of an example recently where that's happened. I think Enron did that, but that's been quite some time. I don't know if that'd be fresh in anyone's brain for this class, but if a company knows, for example, that they're going to that the court is going to make them give over a lot of documents that they don't want to share, it's against the law. It's absolutely breaking the law. It's a criminal offense at that point. If you start shredding documents. But if you've ever heard someone say, shred everything, this is what they're referring to, orders producing documents or discovery. So there's also administrative law. Most government agencies are created by Congress. So when you think of government agencies, think of all of the letters. So the Federal Trade Commission, the FTC, the FCC, the EPA, and there are just loads and loads of government agencies. But these agencies create things called regulations. So the Congress can say, it's illegal to dump oil in the ocean, right? But it's not like members of Congress are going to be standing out on the shores of the Atlantic, making sure no one does that. So they create the Environmental Protection Agency, and that agency oversees the laws, enforcement, actions, et cetera, of all of the laws that Congress passes. So another source of law, and it's often not looked at very much, but sometimes they can make enormous difference especially in some of the businesses if you deal internationally, are treaties with foreign nations. So we have gobs and gobs of treaties with foreign nations. And those are in the link in this presentation. And we're not really going to touch on them much in this class. But essentially a treaty is the president can say, this is our agreement with this country. I think the most recent one, or the most well-known that affects our day-to-day in the United States, is maybe NAFTA, because that's our North American Free Trade Agreement, where we can trade freely between Mexico, Canada, et cetera. Criminal law has a very short section in this book. So we don't, I think we cover one chapter of it, which is too bad because criminal law is fun. And I don't even know if there's another criminal type of class offered at Mac, but it's a fun course to kind of understand how criminal law works. But essentially, the concept of criminal law is that these are acts that are so threatening that all of society has outlawed them altogether. When you go to court, the victim is not a party. So the victim isn't part of the proceedings. They're a witness. They're called in for, a witness to the crime, which of course they were a party to the crime, but they're not a party as far as the proceedings go in court. The district attorney represents all of society. So if you see a case, it's called The People versus John Smith, because the people, which is all of us, are represented by the district attorney, because that person or the defendant has committed a crime against all of society that we have deemed should be illegal across all of either the state, county, US, whatever it is. Coffee. So the government can punish people who break these laws with either imprisonment, with fines, or they can do a combination of those. But any money that goes that's collected from fines goes to the state, not necessarily to the victim. Now we do have victim compensation funds, but those are entirely different things. Fines collected as a result of committing a crime that the judge imposes during sentencing do not go directly to the victim. So civil law, which is mostly what we're covering in this course, essentially regulates the rights and duties between parties. So what do I have to do? What do you have to do? And then the court often comes between us to decide who's right. So for example, I try to think of some things that maybe you guys might be more familiar with. And I think, a lot of people might understand lease agreements. So if you skip out on a lease, if you leave early, if you don't pay your rent, if you leave, that's not a criminal act. You're not going to go to jail for that. But you certainly may be sued in court for that. So now say you skip out on your lease and you come back to the place later and you rip down the fence. Now you've committed a criminal offense, right? So now you're in trouble for something that you've done. You're in a criminal court for ripping down the fence, and they can sue you for skipping out on the lease. But you have to understand these are two completely different matters in two different courts. So we have civil law, we have criminal law, and rarely do the two meet. I think a good example would be, and this isn't even a good example, I'm so much older than you guys, but I'm thinking specifically of O.J. Simpson, because this was all over television when I was younger. So O.J. Simpson gets charged with murder and goes to court and is deemed innocent by the court that, he did not commit the crime. The family then takes him to civil court to say that he was responsible for their deaths. And what they had to prove was much lower than the criminal court. And so he was held liable in civil court and had to pay millions of dollars to the victim's family in civil court. These were two entirely different cases, different courts, different judges, different everything. So let's go back to the biker issue on slide 1. And page 14 of your book references this case. It's called, I don't know how to say it, but I'm going to say Kane because it looks like the way you'd say Kane in Kansas. So Kane versus PubZone. This is an actual case. It's something that actually occurred in New Jersey in 2003. So your book is referencing an actual case, which is listed in part starting on page 14. A major part of this course, and honestly, understanding United States law, is understanding how to read court cases. It can be extremely difficult. The benefit, something that your book does that law school does not do, is they give you very small, concise excerpts of cases. I've seen decisions that are hundreds of pages long. Some of them are 4 pages long, but the 4-pagers are extremely rare. They're generally these gigantic analysis from judges about, the rule of law and understanding the rule of law in combination with the facts given for the case. But essentially, to understand the parts of reading a case. So first of all, you have the parties, which you have the plaintiff and the defendant. The plaintiff is the one making the complaining plaintiff. The other person is the defendant defending themselves. So someone brought the case to court. I'm upset about this thing that another person did. That's the plaintiff. And the person defending themselves, the defendant. It's pretty simple. The first part, which you can see listed on page 14, are the facts of the case. The facts of the case are generally agreed upon, for the most part, by both parties. So the plaintiff's attorney and the defendant's attorney will both put in their version of the facts, which is kind of, I guess, how we would sound argumentative as attorneys, right? Because you can say things very differently, where the same set of facts might exist, but you could say them very differently. So you'll have to, we'll think of some examples in class about it later. And you should certainly think of some, as you're reading through here and kind of going through the slides here. And then the very most important part of the case is the issue. So we have a set of facts that comes down to the question that the court has to decide. So once you know that issue, once you know the issue of the case, it makes reading everything else far more clear. So if we go back to the initial set of facts with the bikers. So the bikers they're known gang members, walk into a bar. The bar has a set of rules to keep gang members out of the bar. Why do they have that set of rules? They have the set of rules because they know they're dangerous. They've experienced violence there before, and they know that gang members that come into their club wearing colors generally are more violent. These are issues that the bar has dealt with before. So the issue for the case for Kane versus Pub, you can also find that on 14, and the book points the issue out to you. Did Pub Zone have a duty to protect Kane from the biker gang attack? So was it the bar's responsibility to protect the innocent man from bikers? The court goes through an analysis, which is listed both on page 14 and over to page 15. The judge analyzes the law. He analyzes case law to see what have we decided before, what are certain statutes in this case that may apply to this, and then he applies it to these certain facts. So then with the holding, a holding is the judge says this party wins. In this specific case with the bikers, the judge said that the bar did have a duty. So he answers to the issue. The issue was, did Pub Zone have a duty to protect the innocent man? Yes, they did. And the judge goes on to say that the bar had a duty to protect him because they were aware of violence from a known group of people that they should have kept out. They did not stop them at the door. They did not call the police. They allowed them to stay. Violence occurred. So they reasonably should have known that an innocent person would have suffered injuries based on their inaction to do anything. Therefore, the holding of this case, the plaintiff wins. So the bar is liable and must pay. And I believe in this instance, I believe that a jury awarded Kane $300,000 in damages because of his injuries suffered. So in this particular case, the defendant appealed. So a jury awarded him $300,000. The defendant appealed. So essentially they said, we don't agree with that. We think the judge was wrong. We think the jury was wrong. So the judge in that case, and I'm trying to go back here, and we may have to reread this, but I'm fairly certain that the judge in the case where the jury awarded him $300,000, the judge said, I don't agree with the jury, so I'm going to set it aside. I'm going to say that the jury was wrong. And judges can do that, which sounds crazy. It's always sounded crazy to me, but it's true. So on appeal, the court said, the judge reinstated the jury's decision by saying, no, the judge agreed with the jury. The bar was liable and he should be paid for his injuries. I think reading cases is a difficult concept to understand, but once you understand how to read it, you could skim and scan for things really quickly. And then you have superpowers in understanding how the United States law works, because this is exactly how it works. I think I've already talked through this slide, but the book uses extremely condensed opinions. And that's what they're called. They're called court opinions. And this is a definition through a legal dictionary, but essentially it's a statement that's prepared by a judge announcing a decision of a case. So it discusses what the court has deemed the exact facts are, the rationale behind their decision, and then the holding or what that judgment is. Generally, it's in writing. Often, you see them in criminal court is honestly the only place I've ever seen them, where the judge will say out loud, a jury finds you guilty. Here's what you've done. Here's my opinion about it. That sort of thing. I've only ever seen that in criminal cases, but not to say it couldn't be done other places. That's just where I've seen it. So, and we've talked through this also, but here's just sort of a short and sweet way to look at it. So Kane versus Pub Zone. Mr. Kane, Carl Kane is the plaintiff. Pub Zone is the defendant. There's a statement of facts about exactly what happened, where the bikers walked into a bar dressed as bikers. They walked past bouncers. They were served drinks. They were allowed to stay there. Nobody called the police. Those are the facts. And then they attacked someone who required surgeries and incurred several injuries. So what is the issue? what is the issue that the court is deciding? They're deciding if the bar is liable to him. They analyzed the law, they analyzed the issue. The judge said they did have a duty to protect him. We'll also see these words a lot as we're going through cases: reverse, remand, and affirm. To reverse something means that when you're reading a case on appeal, it means that the winner now becomes the loser from lower court. So if the judge would have reversed this opinion, he would have said, no, the pub is not liable. I'm reversing the decision. To remand means the judge is going to send it back to a lower court to do something else. Maybe, remanded for further analysis on an issue, or to say maybe, one of the pieces of analysis were incorrect and they need to do something differently. And then there's also to affirm, where the judge agrees with what's happened and then they don't change the decision at all. So those are the three things you'll generally see on an appeals case that you read throughout the semester, whether a judge reverses, remands, or affirms. So on page 17, there is a section of the book called Exam Strategy, to kind of understand how we examine cases and how the book specifically examines them. So there's the question or the statement of facts that's on page 17. It's discussing the Big Red Traveling Carnival. So then you have to isolate the legal issue. So the question on page 17, the statement of facts essentially is that a carnival comes to town. A man parks in the parking lot at 8 o'clock at night and he's robbed at gunpoint. He's beaten, and the person also took his money. There are a lot of police officers on the carnival grounds, but none were in the parking lot. So the man, his name is Tony, he says that if the parking lot would have been better lit, that he would not have been robbed and beaten. So essentially what he's saying is that the carnival had a duty to protect him from violent crime. So in the strategy, the court goes back and says, okay, well, what's being disputed here is just like the pub zone case. We look at that for precedent because it's something that's happened before. So we look there and we say, okay, well, that bar had a duty to protect a person because they knew that crime could happen to that person. In this case, crime had never occurred in that parking lot. So to assume that a person would be a victim of a crime in a place where crime had not happened before isn't reasonably foreseeable that violence may happen again. So in this case, the judge says the carnival is not liable to the person who suffered a violent crime. Hopefully that makes sense. If it does not make sense, we will talk about it more as the, either you can email me questions, we can talk about it in a different class, whatever, because I know that stuff, it really is confusing because it's arguable whether or not, and I say arguable, that's what lawyers do. You argue whether or not someone has the duty to do something. And based on this set of facts, using pub case as precedent, the judge would have to say that there was no duty to protect that person based on precedent. So that's the last slide for today. You guys have an assignment for chapter 1 that is in Bulldog. So as you're working through that assignment, and if you're struggling, if you're having problems with it, don't sweat it too much, do your best, and then we'll go over that stuff together. Obviously, if you have questions, I'm your professor, reach out, I'll help you. Go through those. I don't remember exactly what they are now. They are in Bulldog, to get those turned in. And in the class where we're meeting with each other, the next time we can go over any questions that you have if you want to wait till then. All right, thanks.